she kept his real father out of his life for about 2 years.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, defendant appearing improper. There are two matters before the court: the plaintiff's motion for temporary custody, parenting time, and defendant's motion to determine child born out of wedlock. We'll address Mr. Todd's motion first. I guess I'll ask Mr. Durham, in consideration of your motion, are you contesting or disputing custody or anything?
Your Honor, I'm disputing the custody of the oldest child.
Okay, then go ahead, Mr. Todd.
Thank you, Your Honor. Your Honor, the parties separated in September when a PPO was granted. Since that point, the PPO has in fact been violated. Since separation, defendant has had no contact and no parenting time. The motion actually is not necessarily accurate at this point. Mr. McDermott did request some parenting time in late November, and my client indicated that that would be fine as long as it was with a third party neutral, or alternatively, it could be supervised by his mother. We do believe it's in the best interest of the children for mother to retain sole legal and sole physical custody, with parenting time only being supervised. We've outlined those reasons in the motion. Defendant has not spent one overnight alone with the children ever, including prior to separation. Defendant has significant anger issues. He has chased one of the children up the stairs, saying he will beat their butt. That child was 6 years old. We have a recording of this. Additionally, defendant has a pretty significant criminal history. He pled guilty in 2023 to assault with intent to do great bodily harm less than murder. During this particular incident, he was drunk. He forced plaintiff downstairs, holding her hands behind her back, and began to choke her while she was calling 911. And also he had a hatchet and was threatening her. Defendant has uncontrollable fits of rage and anger. Additionally, he cannot provide a stable or consistent environment for the children in any way. In June of 2024, there was an incident where he was drunk, put the children in the car, and then proceeded to do burnouts. In July of 24, there was an incident where a defendant threatened to murder someone. The children woke up during this incident, and then defendant started to yell at the children. Later in July of 2024, there was an incident where defendant was drunk, yelling at both plaintiff and the children, calling them pussies and saying that he would teach them a lesson. We have a recording of that. In August of 2024, there was an incident when defendant was drunk. He cut off the power to the home, and plaintiff woke up. Defendant had jelly covered on his face and was holding a knife. We have pictures of this incident as well. Additionally, there was a hit and run, which defendant admitted to, and we have this in recording. Given all this, we believe it's appropriate that he obtain a psychological evaluation and comply with any and all recommendations prior to any unsupervised parenting time. This behavior is continuing to get more aggressive and worse and uncontrollable. Alternatively, my client is a stable income as a teacher and a stable home for the children, has a strong connection with the children, and we are requesting child support to be backdated from the date that we filed this. So in total, we're requesting sole custody be given to my client, defendant complete a psychological evaluation and comply with any recommendations prior to unsupervised parenting time, but he can have supervised parenting time through a third party neutral, or alternatively his mother, and we would respectfully request that that be limited to 3 hours per week.
Okay, thank you. Mr. McDermott, what's your response?
Your Honor, well, she's accused me of being extremely intoxicated multiple times, even to the point where telling my parents that I'm drunk in the driveway. And my dad actually would come over and make surprise visits and find that I had not drank anything. I was not drinking during the burnouts. When I got arrested for putting my hands on her, I went through the entire program, and she dropped the charges at the day of my court date, and the state picked it up. I went through their entire program, was released off probation early, and I was even offered a job. The reason I've had no overnights is because I don't quite understand the PPO, and I was seeing my children at the house up until 11/17/24 when the talk of splitting items and divorce came up. And I do have this on recording. And then 11/24, she had canceled on me. I had a visit on 11/25, a video visit. And all these incidents where apparently I was drunk and obscene, my question is, how come the police were never called then if I was such a danger? And I apologize, Your Honor, for this, but I did actually go to Berry County mental health and had an evaluation done, but I didn't get my letter back until Saturday, so I wasn't able to send out the appropriate copies. But I do have that, and I was going to send those in today.
Okay. Great. Thank you. Anything else, Mr. Todd?
No, Your Honor, but I guess just the PPO does allow for peaceful contact as it relates to the children.
Well, what the court will do in the interim, the court will grant to the plaintiff legal and physical custody support pursuant to guidelines to the date of notice of your motion, Mr. Todd. Court would allow supervised parenting time for up to 5 hours on Saturday from 12 o'clock noon to 5 o'clock p.m. That can be exercised at his mother's home or at some other third party that the plaintiff would approve and agree to. And Mr. McDermott, you'll have to provide that psychological evaluation to Mr. Todd within 7 days of today's date.
Yes, Your Honor.
That will take care of that part. Mr. McDermott, now we'll address your motion to determine child born out of wedlock. Go ahead, sir.
Well, when I had met the plaintiff, she was already pregnant, and she kept his real father out of his life for about 2 years. And after that, I mean, he has been seeing him all the time. He's over there almost every weekend, and I just don't feel it necessary for me to have to pay support when his real father is seeing him consistently. And as far as me signing the birth certificate, to be honest, I really didn't even know what I was signing.
Yeah. Well, that's unfortunate. Okay. Mr. Todd had filed a response which was consistent with what this court had was thinking when I found this. Mr. McDermott, pursuant to the statute, which is 722.1441, you're required to take action and file your action within 3 years of the child's birth. Child's 8 years old, so you've missed the statute of limitations for filing this action. What's your response to that, sir?
Your Honor, I was not aware of that.
Okay. Well, unfortunately, whether you're aware of it or not, it's still the law. And as a result, the court can't just ignore the law because you weren't aware of it, unfortunately. So the court doesn't find any basis at the current time for your motion in this matter. So I'm going to deny and dismiss the motion. I'll ask Mr. Todd that you would prepare an order to that extent, as well as a motion on the other the matter. It might be better if you did them separate, that way.
Sure.
Rather than just one order.
Okay, absolutely.
Okay, that will be the ruling of the court, and you're free to go and have a good day.
Oh, I apologize, Your Honor. One other thing, can I request an exchange of income within 7 days?
Yes.
Okay, thank you, Your Honor.
Yeah, Mr. McDermott, send to Mr. Todd, proof of your income. And he will send the same to you as proof of the plaintiff's income.
Yes, Your Honor.
Okay,
Zach was the father of the child on the birth certificate, that she was leaving him. I believe it's in the best interest of the child to keep the father as is.
And she told you that he thought you were the biological father. And were you getting any kind of sense that she was expecting you to step up and do something?
Possibly. It was really hard to tell because she was still living, dating Zach. She was kind of doing it behind his back at that time.